call on Deputy Sean Kenny, who's sharing time with Deputies Dara Murphy, Brendan Griffin and Peter Fitzpatrick. 5 minutes each.
Thank you, Cancorla. I welcome the fact that legislation is being proposed to increase prosecution of white-collar crime. This is a very serious type of crime that, as this House knows too well, has caused the most serious damage to the nation economically, socially and morally. This bill is radical in that it provides for the 24-hour period of detention by Gardaí for serious offences to be broken up into segments. As I understand it, under the existing criminal law, where arrests and detentions of suspects is concerned, there is provision for a break from questioning from midnight to 8 a.m. The new bill allows for temporary release under the 24-hour period that will see the detained suspect released for the purpose of assisting an investigation, and will then see the suspect being recalled to detention or else to have the detention ended if that is deemed to be appropriate. The bill has this mechanism, Cancorla, included in order to give investigators the ability to check and reference facts and examine documents, which is an area where past investigations into white-collar crime has been hindered. I very much welcome that provision, as well as the new powers given to Gardaí, which allow them to apply to the District Court to obtain an order to compel individuals or corporate entities to produce documents or to make statements related to a specific investigation. These are measures in the bill to prevent delays arising from the refusal to disclose a document on the basis of legal privilege by permitting investigators to have recourse again to the District Court to determine whether the claim of privilege is justified. This will help very much, Cancorla, in such instances which very often have ended in a stalemate. These are all positive measures which I welcome. I understand that the Minister has stated that once enacted, the legislation can be availed of to assist investigations currently underway as well as future investigations, and I think that's very important because there was a belief that some people may escape. This is very much to be welcomed, as it means that the current investigation of public concern can benefit from the new legislation as well and not be exempt from it. On the subject of investigations, the Minister should consider the substantial strengthening of the Office of the Director of Corporate Enforcement. More staff for this office is required to investigate the crimes and misdemeanours of those involved in white-collar crime. Make no mistake, the electorate expect this, and rightfully so, and it would be remiss of this Dáil not to take action in that regard. What has occurred with the recent general election is a change in the mindset of the Irish electorate. Fianna Fáil failed to convince the people that what they did was right and that what they did was in the people's interests. Being disingenuous with a sincere face will not work in Ireland for a long time to come. The Irish people will now, I believe, turn rapidly against any political force if there is any suspicion that they are not working in the public interest, in the interest of the people and of the community. This is why we must take action to investigate white-collar crime. I would suggest to the Minister that he consider an aspect of the Companies Act that I think would add further weight to what is already a very good piece of legislation. I think it would be fair to say that individuals in white-collar crime, even if the offence is withholding of information and not even more serious offences, are not individuals that this society wants to see involved in Irish business life. Section 150 and Section 160 of the Companies Act 1990 allow for the restriction or disqualification of directors who breach the Companies Act. Would the Minister consider extending these two sections into this bill? I believe this would add even more weight to the legislation. Indeed, Section 160 of the Companies Act 1990 reads in such a way that it may already apply. It reads, where a person is convicted on indictment of any indictable offence in relation to a company or involving fraud or dishonesty, then the period of 5 years from the date of conviction or some such other period as the court, on the application of the prosecutor having regard to all the circumstances of the case, may order. I would ask the Minister to take note of this suggestion and to consider it as an amendment. Thank you, Cancorla.
Thank you, Deputy. Deputy Dara Murphy.